Imagine getting fired for making orgasm noises at your desk.
Oh, wow.
Yeah, right? Or imagine a workplace so toxic that a federal safety regulator actually has to treat the company culture itself like a deadly exposed electrical wire.
That is quite the visual.
Well, today we are taking a deep dive into the legal ecosystem of your day job. I mean, if you calculate it, you spend about a third of your life at work.
Right. It's a massive chunk of time.
Exactly. It's a huge part of your existence operating under a very specific set of rules. But how well do you actually know the rules of that game? And more importantly, what happens when the people holding the rule book use it against you?
It's a really critical question because I think most of us just view employment as, a simple transaction. Like you perform your duties, you get your wages, and that's it.
Right. Clock in, clock out.
Exactly. Yeah. But it is not a simple trade. It's this highly complex, legally binding ecosystem, and it requires procedural fairness to actually function. So when that ecosystem breaks down or when it becomes actively toxic, the fallout isn't just, a bad day at the office.
It can ruin lives.
The mechanics of that failure can be absolutely devastating.
Which is exactly what we are going to unpack today. Welcome to this deep dive, everyone. We are looking at a stack of incredibly eye-opening sources from the Australian Workplace Discrimination Representatives, or AWDR.
Yeah, and they're a firm of non-lawyer workplace relations specialists. They've spent over 30 years representing everyday Australians.
Over 16,000 clients, to be exact.
Which is wild. So our mission today is to really unpack the reality of modern workplace rights in Australia. We're going to look at everything from those bizarre reasons people get fired, all the way to the tragic, fatal consequences of toxic work environment.
It's a huge spectrum. It really is. So as you listen today, I invite you to evaluate your own workplace through this lens. Because the sheer variety of disputes AWDR handles, 7 days a week, it's staggering.
They really cover the entire spectrum of human behavior and, frankly, corporate dysfunction. They represent individuals in unfair dismissals, general protection disputes, sexual harassment cases, toxic workplaces.
Oh, and that very specific legal concept, constructive dismissal.
Yes, constructive dismissal.
Let's actually pause right there for a second because we need to define some of these terms.
Yeah.
A lot of these phrases get thrown around in corporate handbooks, but the actual mechanics of them are rarely explained to employees.
Right, they keep it vague on purpose sometimes.
Exactly. So let's start with constructive dismissal. What is the actual mechanism there?
Well, constructive dismissal is essentially when you aren't formally fired by your boss, but you are forced to resign because the work environment has been made just completely unbearable.
So they don't say, you're fired.
Right. The employer doesn't have to explicitly say those words to have illegally terminated your employment. If they say, create a hostile environment or strip away your core duties to the point where a reasonable person has absolutely no choice but to leave, the law actually treats that resignation as a dismissal.
It's a forced exit.
Exactly.
So for everyone listening, if your boss ever makes your daily life so miserable that you feel you have to quit just to save your own sanity, the law might actually view that as them firing you.
Yes. And that opens up a pathway for legal recourse under the Fair Work Act.
Wow, okay.
Another term people often misunderstand is a general protections dispute.
Right.
Because the Fair Work Act guarantees certain basic rights, like the right to ask your employer what your pay rate is.
Which you'd think is pretty standard.
You would think. Or the right to take sick leave, or the right to participate in lawful industrial activities, like a union meeting.
And if you ask about your pay, and then suddenly, surprise, surprise, you find yourself written up for a mysterious performance issue.
That is exactly where the General Protections Clause kicks in. The law protects you from facing what they call adverse action, simply for exercising a workplace right.
But the problem is, proving that connection has to be incredibly difficult for just one individual employee going up against a whole corporate machine.
It's incredibly difficult, which is why having specialists matters.
And the spectrum of what triggers these disputes is just wild. Just looking at the headlines from the AWDR blog, it is absolute chaos out there.
It really is.
You have a reality TV MAFS villain whose corporate career gets ruined by the public backlash. You have people being dismissed for literally fart pranks in the office.
Yeah, that's a real case.
And you even have tech workers fired for setting up surveillance on their own employers. At first glance, it sounds like a sitcom.
It does sound absurd. But there is a deeply serious legal reality underneath all those headlines. Every single one of those bizarre scenarios has to be adjudicated through the strict lens of employment law.
Right.
Like, was the fart prank actually a breach of health and safety?
Did it count as a hazard?
Exactly. Or did the reality TV star's personal life breach a specific code of conduct in their contract?
Hearing all this, navigating the Fair Work Act sounds less like reading a rule book and more like, I don't know, trying to defuse a bomb blindfolded.
That's a great way to put it.
But here's my question. Why do people need these non-lawyer specialists from outside the company? Why not just, walk down the hall and go to human resources?
Ah, well, that is a fundamental misunderstanding of corporate structure.
How so?
Why not go to HR? Because human resources, by its very definition, exist to manage the company's resources and mitigate the company's risk.
So they aren't there for you?
No, they do not exist to provide therapy or legal support to the individual employee. In fact, the AWDR sources feature an entire article about what they call the HR manager from hell.
The HR manager from hell.
Yeah, these are managers who use their knowledge of the rules to be retaliatory or coercive, or to actively protect predatory executives.
We see that weaponization of language all the time, actually. Let's look at the term redundancy.
Oh, that is a perfect example. If an employer says your role is a genuine redundancy, they are legally stating that the specific job you do no longer needs to be performed by anyone in the organization.
The structure has changed.
Right.
But if they let you go, and then you see someone else sitting at your desk doing your exact job a week later,
Then it wasn't a genuine redundancy. That was an unfair dismissal disguised as a corporate restructuring. And unless you understand that legal distinction, you might just pack up your desk and walk away thinking, well, it's just bad luck.
wow.
That is why AWDR exists, to act as a buffer and a representative for people who just don't know the exact terminology required to defend themselves.
So we laugh at the absurdity of fart pranks and reality TV drama, but there is a psychological mechanic at play here. When a workplace culture normalizes ignoring the rules, or when HR uses the rule book to trap employees rather than protect them, it escalates.
It absolutely escalates.
And when it escalates around vulnerable people, it turns deadly. Which really brings us to the dark side of this. Let's talk about the 2026 coronial inquest finding regarding a woman named Natasha Stojkoski.
Yes. This case is a harrowing look at what happens when the legal and ethical ecosystem of a workplace entirely collapses. Natasha was a sales assistant at the Good Guys in a Melbourne suburb, Thomastown,
And she'd been there a long time, right?
since 2009. By all accounts, she was a very dedicated employee for nearly a decade.
But then, on October 23, 2018, she suffered a severe physical trauma. She was operating a stock-moving vehicle and collided with an overhanging bulkhead.
Just a horrific accident.
She was actually crushed underneath a wall for up to 10 seconds. And that incident left her in persistent, permanent physical pain.
And in a functional ecosystem, that physical injury is where the workers' compensation and rehabilitation systems would just seamlessly step in.
Right.
But the inquest revealed that the physical injury was only the catalyst. It was the hostile environment upon her return to work that really broke her.
When she returned on light duties, she walked into a literal wall of hostility. The coroner accessed her personal notes, and I have to say, they are incredibly difficult to read.
They are.
5 of her colleagues essentially organized a silent treatment. They would ignore her, and when they did speak, they made sarcastic remarks about her inability to pull her weight.
Completely disregarding that she had literally been crushed by a wall.
Exactly. And by August of 2019, she was actively crying in meetings with management. She couldn't sleep, she couldn't eat.
Let's look at the institutional response here, because
Yeah.
it is a textbook example of systemic failure. When an employee comes to management visibly deteriorating because of how they're being treated, the employer has a strict legal obligation to ensure a safe working environment.
They are required to launch a formal investigation.
They are. But instead of launching an investigation, the store manager emailed the company's HR department and said her complaints, quote, didn't smell right.
Didn't smell right. Unbelievable.
He completely conflated her bullying complaints with her physical performance issues, and his solution was just mind-boggling. He suggested Natasha just sit down and have an informal chat with the 4 people allegedly abusing her to, resolve the issues themselves.
It is a profound abdication of duty. You have an employee suffering from severe anxiety, and management's proposed remedy is to lock her in a room with her tormentor.
Right. It's completely unacceptable.
Wait, I'm stuck on something here because the timeline gets even worse. Natasha realizes the store manager isn't helping, so she goes over his head to the company's senior HR manager. They get on a 45-minute phone call.
Yes.
Natasha is audibly crying on this call. She is highly distressed. The HR manager already knows the identities of the alleged perpetrators, yet the HR manager claims there is a lack of detail to launch a formal probe.
Yeah.
How does a 45-minute distressed phone call not trigger an immediate legal investigation? Like, how does HR justify that?
They justify it through a psychological mechanic called filibustering.
Filibustering.
Yes, and this was heavily criticized during the coronial inquest. Filibustering in HR is an administrative defense mechanism. So instead of addressing the core issue, you delay. You ask the employee to fill out more forms.
Oh,
You
wow.
demand written logs with exact times and dates. You create so many administrative hurdles that the broken employee, who, remember, is already struggling to eat and sleep.
You just give up.
Exactly.
Yeah.
Dr. Gregory White, a psychiatrist who reviewed the case, he described the company's insistence on informal resolution and administrative delays as dreadful and akin to victim blaming.
And the most chilling detail of this entire case happens right after she finally breaks. On August 26, 2019, the environment became so hostile, she had to cease working entirely.
She went on leave for physical and psychological distress.
Right. And just 10 days later, 10 days, the company's injury management lead preemptively wrote to their insurer to block both her physical and psychological claims.
This is a crucial and honestly often invisible mechanism of a toxic corporate response.
How does the law even allow them to preemptively block a claim?
Well, the workers' compensation system relies heavily on initial liability assessments. So employers can submit dispute notices to their insurers, claiming that the psychological distress is due to reasonable management action regarding performance, rather than workplace bullying. By doing this, they instantly shift the burden of proof onto the employee.
So instead of the company having to prove they provided a safe environment, Natasha suddenly has to hire a specialist to prove she's actually a victim.
Yes.
All while she has no income and is severely traumatized.
Yes, it starves the employee of resources. They disputed her claims without ever conducting a formal investigation into the bullying itself. The coroner explicitly noted that this preemptive legal strike reinforced Natasha's feelings of absolute isolation.
And the conclusion to Natasha's story is just an absolute tragedy. After nearly 2 years of fighting this isolation, she took her own life on May 2, 2021.
It's heartbreaking.
It really is. And when Coroner Audrey Jameson delivered her findings in April 2026, the language she used was staggering. She found a clear and cogent link between the hostile workplace and Natasha's death. She stated, and I quote, "The good guys let everyone down. Significantly, they let Natasha down."
And it goes even further than that. The coroner noted with great disquiet that the company seemed to actively hamper the inquest itself.
Wait, really?
Yes. They failed to provide key documents. They breached court directions by giving restricted files to their own medical expert.
Unbelievable.
The coroner found their responses to the bullying were characterized by denial, trivialization, and false conciliation. It was just a complete institutional failure to recognize a human being in pain.
Natasha's case is a tragic example of a localized failure, right? A specific store, a specific manager, a specific HR representative choosing to protect the bottom line instead of the worker.
Yes.
But it raises a terrifying question. What happens when that toxicity isn't just a localized issue? Like, what happens when the hazard is a systemic, macro-level corporate strategy?
To understand that, we have to look at one of the most high-profile workplace crises of 2026, the National Australia Bank, or NAB.
Right.
If Natasha's case was a micro-failure of individuals, the NAB case represents the potential macro-failure of corporate culture at a massive scale.
Early in 2026, 2 NAB employees died by suicide in quick succession. The first incident, on March 5th, was viscerally shocking. A male employee fell from the 14-story global headquarters in Melbourne.
And this didn't happen in the middle of the night.
No, it happened right in the middle of business hours. His colleagues literally watched it unfold as they were walking back to the building from lunch. One witness told the media, "It happened too fast, couldn't think fast enough to look away."
Just horrifying.
And then a second death of a staff member on long-term personal leave occurred just weeks later.
Whenever an incident of this magnitude occurs, it really cracks open the facade of the corporate culture. The silence breaks. Whistleblowers and former employees immediately began coming forward to the media, and they detailed a culture that was consistently described as dehumanizing.
The allegations are intense. We are talking about overt, normalized managerial bullying. One former employee described a dynamic where staff were being yelled at in lunchrooms for performance in front of the whole floor.
In front of everyone.
Yeah, they were leaving people crying in front of their colleagues over metrics.
And this behavior doesn't happen in a vacuum,
Yeah.
you know. It's a symptom of a structural context. Former employees noted that older, more experienced staff were allegedly being pushed out or made redundant.
While at the same time, the performance targets for the remaining staff kept getting pushed higher and higher.
Exactly. Staff were reportedly being forced to work on their days off just to meet these targets, and even then, they were being reprimanded.
Which leads to a massive surge in what the industry calls quiet quitting. And it's not a trendy buzzword, it's a survival mechanism. An employee becomes so burnt out and fundamentally disillusioned that they just do the bare minimum required to keep their paycheck while they desperately look for an escape route.
Right. And to understand the pressure cooker at NAB, you have to look at the macroeconomic moves happening in the background. In September 2025, just months before these tragedies, the bank announced 400 role cuts.
400 cuts.
The stated corporate reason was to simplify team structures. But simultaneously, an NAB spokesperson confirmed they were creating new roles in offshore locations like India and Vietnam.
Let me play devil's advocate for a second here. Look at this from the company's perspective. Corporations have a fiduciary duty to make money. Restructuring, dealing with high performance targets, navigating a demanding boss. Most people just consider that the standard corporate grind.
Sure.
So where exactly does the law draw the boundary? When does a demanding boss cross the legal line into workplace bullying?
It is one of the most common questions AWDR handles, and the legal line is actually very distinct.
Okay.
Under the Fair Work Act, reasonable management action is perfectly legal, provided it's carried out in a reasonable manner.
Okay.
A manager is allowed to set targets, they are allowed to evaluate your performance, and executives are absolutely allowed to restructure a team.
But yelling at someone in a lunchroom.
That is never reasonable management action. That is public humiliation. It crosses the line into workplace bullying if the performance targets are mathematically impossible to achieve, or if they add unnecessary psychological stress without support, or if they are weaponized and targeted at one specific person.
Right.
Furthermore, the constant looming threat of offshoring and redundancy creates severe, chronic job insecurity. And under recent changes to workplace law, chronic job insecurity is no longer just viewed as a bummer of corporate life. It is legally recognized as a psychosocial hazard.
I want to dig into that specific term, actually, because it is vital to understanding modern worker rights, a psychosocial hazard. In April 2026, ComCare launched a formal investigation into these NAB deaths.
Yes.
ComCare is the federal work health and safety authority that regulates self-insured corporate giants like NA, Telstra, and Australia Post. And they are investigating this specifically through the lens of psychosocial hazards. Mechanically, how does a regulator investigate a vibe? Like, how do they measure a culture?
Well, they don't measure a vibe. They measure structural design. Mechanically, a psychosocial hazard is defined as any factor in the design or management of work that increases the risk of psychological or physical harm.
Okay, so it's structural.
Yes. Just as a frayed electrical wire is a physical hazard, a poorly managed restructure is a psychosocial hazard. ComCare investigates this by auditing the mechanics of the workplace.
What does that look like?
They look at email traffic to see if people are working at 2 a.m. They analyze turnover and resignation rates. They interview staff to determine if the assigned targets are actually achievable within standard working hours. Under the model work health and safety laws, employers are legally required to proactively identify these psychological risks and implement concrete measures to eliminate them.
Looking at this objectively, we have two very distinct narratives about this corporate environment. On one side, you have the finance sector union, who publicly called the job cuts a shameful agenda driven at the expense of workers and communities, noting that this is a widespread tactic across the banking sector.
Yes.
On the other side, an NIB spokesperson responded to the tragedies by stating they made health, safety, and well-being professionals available to all 40,000 employees. They offered face-to-face, phone, and online consultations. They insisted the bank is dedicated to creating a workplace where staff feel safe, supported, and heard.
And that is exactly what the ComCare investigation is designed to unravel. They will ultimately determine whether those post-incident support systems were sufficient, or if the fundamental structural design of the work itself was inherently unsafe and contributed to the hazard.
So when we step back and synthesize everything we've looked at today, we've covered a tremendous amount of ground. We started with the Wild West of the Fair Work Act, the bizarre reality of dismissals over office pranks, and the vital need to understand terms like constructive dismissal and genuine redundancy.
But then we traced how those same legal mechanisms, when manipulated, lead to devastating human consequences.
Yeah.
We saw it in the micro. with Natasha Stojkoski at The Good Guys, where a localized culture of HR filibustering and victim blaming isolated an injured worker. And we saw the allegations of it in the macro at NAB, where whistleblowers described a dehumanizing culture of public humiliation and systemic job insecurity.
It all comes back to the ecosystem. Knowing the rules of the game isn't just a corporate advantage.
That's the core of it. Knowing your rights under the Fair Work Act isn't just about protecting your paycheck or, successfully negotiating a severance package. In toxic environments, it is fundamentally about protecting your mental health and your physical safety.
Absolutely.
The message running through all of AWDR's case files is that the legal system is complex, and it often feels weighted toward the employer. But there are non-lawyer workplace relations specialists out there who exist solely to help level the playing field. You don't have to navigate the chessboard blindfolded, and nobody has to suffer in silence.
That is the perfect way to frame it. You spend a third of your life at work, you deserve to be safe while you are there. Which brings me to a final thought I want to leave you with today. Imagine you walk into your office tomorrow morning, and there is a gaping hole right in the middle of the floor.
Right.
Safety regulators would shut the entire building down immediately to prevent someone from suffering a fatal fall. But when the hazard is psychosocial, when the hazard is the invisible culture of the company itself, why do we still expect the employee to fix the floor while they are already falling?
That is the exact question every modern workplace needs to answer.
Thanks for joining us on this deep dive. Keep questioning the rules of the game.